Mr. Chairman, we're live.
Okay, welcome back, everybody on YouTube and in the audience. Our next agenda item is not an action item. This is a workshop with our Valley County Planning and Zoning Commissioners and us. I want to remind everybody that we are live. This is being listened to, so be thoughtful, be careful what you say. And at this time, before we start, I just want to thank all five of you for serving in this position. I know it's been controversial. It's been challenging. You're learning a lot about each other and trying to figure out how to get along and make it work. And that's, to me, is what democracy is about. Everybody has a different opinion, and we're all, at the end of the day, still friends. And I think that's important to state because we are. We're all in this together. So at this time, I'm going to move down there and I'm going to turn it over to Brian.
Okay. So, I don't know if this is my training or Cinda's training, or we're just kind of tag team it. But I guess I can start off. For those of you who have been part of trainings or discussions with me, you'll know I'm pretty informal. Don't typically like to follow an agenda too closely. I did put some notes together and sent that around. Sorry that was so late Friday. Just sure there wasn't anything important on Sunday to do other than planning and zoning notes for me. But if you did get a chance to review those in advance, I will go over some of that information. Recently, I also did put together a memo for the board, and Cinda, I think, sent it out to Planning and Zoning Commission related to the due process requirements for public hearings. So if you have questions about that topic, we can do our best to answer those here today. What prompted the notes, and I'm calling them notes because that's kind of what I did was I reviewed a recent Supreme Court case and just took some notes. And this is a big case from a planning and zoning perspective because the Supreme Court hears probably a dozen or more planning and zoning land use related cases every year. This particular case was one where it kind of took issue with the written decisions that are coming up from counties and from municipalities, and that affects you from the standpoint as you're doing your deliberations. The written decisions actually come from the deliberations that you're doing at the planning and zoning level or at the Board of County Commission level. And so it's really important that we review this because the Supreme Court said, in fact, one justice in particular is really saying that the counties and the cities have got to spend more time and take a little bit more time to develop a reasoned statement to support the decisions that you're making. So the notes that I circulated around were really based on that recent Supreme Court decision. If you're interested in it, you can find it on Google. It's the Northwest Neighborhood Association versus the City of Boise. This is a Corey Barton development in the Old Hill Road area. And what kind of got the case in front of the court was, like all land use decisions, you might find it interesting to know that even in places other than Valley County, not everybody supports land use development. And so there was a citizens group that were opposed to it, and they kind of latched on to one of the criteria for approval was to make sure that there was adequate EMS response time. And so the city of Boise had adopted a policy that 4 minutes was the standard from the time they get a call to dispatch that somebody from either Ada County Sheriff's Office or the EMS fire department would be would be able to respond. Now, the location of this particular development was actually closer to the city of Eagle than it was to the nearest Boise City Fire Department. So there was a little bit of a dispute going on between some of the opponents and Planning and Zoning Commission and the fire chiefs about whether they needed to have a formal contract in place that said Eagle would respond to this kind of thing. So anyway, kind of set the stage for some of the factual determinations. But here's why this is a case that's important to you. Is the Supreme Court basically said, once they looked at the written decision that came up from the city of Boise, they said, we don't like the findings of fact. And the reason we don't like the findings of fact is because the city of Boise basically went through and just cherry picked statements that were made during the deliberations and just basically made conclusory statements like, we find that the response time is adequate. Well, the Supreme Court said that's not your job. When you sit as a Planning and Zoning Commission or you sit as the Board of County Commissioners, you are actually sitting as in similar to what a judge would be doing, which means you have to resolve factual disputes. And if you think about it, that hearing that they were having, you had the applicant and you had some of the testimony that said the response time for the EMS meets the 4-minute policy, and then you would have people from the community come up and say, no, it doesn't. So you have a dispute. And so you have two competing facts, and unless you say, we find that there's enough evidence to support fact A, and we're finding fact A because of these reasons, the Supreme Court saying, that's not going to cut it. You can't just conclude without telling us why you're making that conclusion. So you're confronted with that in all the applications that you see. Is you're going to have one side get up and say, I believe that let's just stick with the same set of facts. EMS response time. I believe the EMS response time meets the policy of 4 minutes per call. People are going to oppose that, and that's what I'm trying to kind of plant the seed with each one of you as you come to these hearings to be focusing on those things. And that's just one fact. You're going to have a dozen or more sets of facts that you're going to have to deliberate on and decide amongst the group of you which facts you're going to find, how you're going to resolve those conflicting set of facts, and what evidence you're going to base that on. So I spent some time in the memo saying, okay, let's talk about evidence for just a minute. What's credible evidence? What's not credible evidence? And kind of laid that out for you. The legal standard, for finding evidence, usually a legal term of art is competent evidence. So I spent a little bit of time, and I don't want to just read the stuff to you. I'll leave that up to you, and I'll spend the majority of the time having a little bit more of a dialogue with each of you. But what competent evidence is versus not competent evidence. And I think what you see often in the hearings that you have is that you have a lot of people from the community that come and testify, and you have to decide whether the information you're providing, or you're hearing they're providing to you is competent or not.
So if my neighbor Joe went and got in his old pickup, went down to the fire station and drove to where that fire would be, he couldn't get there in 4 minutes, that wouldn't be competent.
Potentially no, but and another way of describing competent evidence is trustworthy. Is it reliable? Can you trust it as being good? And the way I delineated it in the memo I provided to you was, members of the community can give you real-time observations. This is what I've experienced. I live in the neighborhood. This is what I see. This is the number of cars that I see coming by, or I called 911 and it took them 6 minutes to come to my house. But if it's speculative or something that's going to happen in the future, then a more reliable source of information like that is the experts.
So then what I should have done is gotten a hold of either Eagle or Boise EMS and said, can you guys make it here in 4 minutes with a statement?
Yeah. And there was some testimony in the record about that, but there wasn't any factual findings from the city that said the fire chief from the Eagle Fire Department came to the hearing and testified that, one, he has the authority to commit his fire station to respond to these, and two, in his expert opinion, he could make sure that one of their trucks could respond within the 4 minutes. If they would have done that, that would have been more than acceptable for the court. But what the court had in front of it was, we find that it meets the requirements of the just a conclusory statement.
So what
A
if,
key point- A key point is that there was a standard that said 4 minutes.
Yes. So you had a question, and then let's come back to that because I think that's important.
what if, as a, let's just say a planning and zoning commissioner, you lived right by the EMS and drove it yourself? Or,
Well, that is the burden that you have as the fact finders in these cases, is you get to decide how you're going to determine what's competent evidence, what's not. Now, if I understand your question right, you are,
personal experience.
as a commissioner going and you're saying, okay, this is coming up. Goes back to the due process memo I sent out before. I'm going to discourage that. Okay. Everybody has their own personal experience, and especially if you've lived in the county your entire life, you know a lot of stuff about what happens here in the county. But remember, you are serving as the judges in these fact-finding cases that are in front of you, and you got to behave like a judge. And a judge doesn't go out before a case and go search for evidence. He's got law enforcement to do that in a criminal case, or however evidence gets presented in the court. There's a set of rules, but the judge doesn't. The judge is not your investigator. And so the risk you take by doing that, Catlin, is that you're considering evidence that's outside of the scope of the record that is in front of you. And that's another issue that the Supreme Court is really pushing back hard on with counties and cities, is that you have to remember that every decision you make has a potential to be challenged in court. And the only thing that the judge is ever going to be able to review is the administrative record that's put in front of him. And that's when people come to testify. That's the staff report that Cinda puts in the record. That's the information that you heard while you were here in this room with the public hearing. If you were relying on something outside of that record, it's not going to be in front of that judge. And that judge isn't going to be able to make a determination based on what you saw personally, and you didn't put that in the record. So if it's absent from the record, it's really impossible to to comply with the requirement that you have a transcribable record from the court. So just remember that every decision, planning and zoning.
Could I just ask one question with that too?
Yeah.
So, Caitlin, in that scenario, what we should not be trying to do is replicate something that's not apples to apples. Because if I'm in my personal vehicle trying to go from point A to point B, I don't have sirens going. I'm not driving over the speed limit. I'm not responding in a hurried fashion. And so it's really not, we're not recreating reality that's on the ground. And I think, Brian, that's what you were trying to get to. You can't replicate what's happening in reality.
Yes, I don't think you are making a fair comparison when it comes to something like that. But at the same time, I was also wanting to make the point that it's really important to rely on the record that's in front of you as the P and Z Commission and the Board of County Commissioners to base your decision on. So we've had that conversation before. And it's really grounded in the notion that you need to have a transcribable record, and there's no way to transcribe what your personal history is.
A question, Brian, because a lot of times you come in, it's natural, hey, with a preconceived, not a bias, but a notion that I know this property, I've been, years ago, I saw half of it was underwater in the spring or whatever that situation was. How do you get that evidence into the written record?
Well, I think that it's perfectly appropriate to ask for information to be put into the record. If you have personal experience or knowledge, there's nothing that says that you can't ask an applicant to have a hydrological engineer or even just pictures or whatever you need, as long as it's in the record from a legal standard. That's what I'm looking for, is have the information that you're basing your decisions on the record. So
So if I have a preconceived notion that I know the water table's high for this CU, so then I would ask them to do a groundwater test.
Right.
Show that data and then put that in the record.
and we've had that come up in the past where it's like in springtime, high water table, we kind of know that's going to be an issue. So let's ask for, as part of either the application package or somewhere along the way, that a hydrologist goes and does a study and targets that study during that important time of the year where you know you might have the biggest problem with water. And that's fine. So from a reviewability standpoint, once that's on the record, everybody at the table gets access to it. The applicant gets to see it. The opponents get to see it. P&Z gets to see it. Most importantly, when we get to district court, the district judge gets to see it.
So question on Elt's example about the high water and getting back to your competent evidence standard. If you have 2 or 3 witnesses or people that testify to the high water situation, is that in the record then?
It is, absolutely. It is. And that's where you, as a judge of the facts, have to determine, is that competent evidence? Is it reliable? Do they have,
I would say it's not.
well, yeah,
Even though the neighbors say, yeah, we've seen this field underwater, well, I need soil conservation, I need a water geologist, somebody to come in and confirm that this ground is underwater, even though everybody around knows it's underwater.
We
I don't think
can't,
that's gonna cut it. I don't know.
we can't put it in there because we're no more confident than they are, as far as our knowledge.
maybe.
Even though we
You
know.
could if you said, if you wanted to submit it for the record.
Well, if you had enough people coming to you saying, hey, this is underwater half the year, you guys can't build this thing here, which happens a lot.
Sure.
Okay, then let's ask for a soil test,
Exactly.
let's drill some test holes, let's find out.
Exactly. That's where you start.
And that's part of the, it's just not that, we all have preconceived notions about different applications. It's just natural.
Yep.
And so you gotta figure out how to get that on paper for the record.
And I guess I just want to say this. I don't think this is a bright line, black and white rule. This is the challenge, and this is what makes your job hard, is that you have to determine, maybe individually as a commissioner, but ultimately you gotta vote and do it as a group, but you have to determine what you consider to be competent, reliable, trustworthy evidence. If you find that 2 or 3 people from the community that live nearby made visual observations and you find that competent, I'm not going to tell you it's not. If you need more information to feel comfortable that that's not just an anomaly, that isn't just a one-off problem there, maybe a hydrologist would give you more detailed information, and that's what you would find competent. That's what makes this whole system work correctly, is that you're deliberating on those issues and you're talking about them, sometimes debating, whether or not your point of view is right and the other person's point of view is wrong. That's why we have a 5-member commission instead of just one person making the decision.
So another example of this that might be a little harder to put our finger on, I'm gonna, by name, say Espridge, because everybody knows where Espridge is. And we've had numerous applications on the west side of that, and we've heard time and time again about congestion, safety issues. Where can you establish that that is a credible concern that meets that competent evidence standard?
Well, so that's actually a good transition to go back to one of the really important points that Cinda brought up a minute ago that I didn't want to forget to talk about, and that is bringing your factual determinations back to the criteria that you have to judge the facts against. And that's another big part of this Northwest Neighborhood Association case. And so instead of addressing your Espridge question directly, I'm going to go right back to the 4-minute response time, just because that's easier to talk about. It's easy to visualize. So I told you that Boise City had adopted the standard that they wanted a minimum 4-minute response time for all Northwest neighborhoods, or for all new subdivisions. That criteria, they kind of quantified this response time as a way to determine when and where they needed to build new fire stations based on new growth. And so they had adopted this policy and made it part of their city ordinance, actually. And so they had established this criteria that says you got to have a fire truck or an ambulance within 4 minutes of the subdivision. Otherwise, you don't meet this level of criteria, or this really important criteria to us. You have to tie it back to the ordinance, I guess is what I'm saying. So you weigh the information in the record. From what I could tell, reading the case, it looked like there was a lot of discussion in the record about whether or not it was going to meet 4 minutes or whether it was not, and whether there needed to be a formal agreement between the city of Boise and the city of Eagles that they would share this geographical area. But at the end of the day, the court said, one, we're not going to accept conclusory statements as acceptable findings of fact. We need to hear what evidence you're placing on how you're making a finding. And 2, you need to apply that to the criteria that's established. And that it's clear. In your Espridge example, I'm not so sure that it's quite as clear. 4 minutes is easy. It's like 4 minutes, you put a stopwatch on it, you get the fire chief to come up and testify. And so I use that as an example just to kind of oversimplify the point that I'm trying to make is when you look at an application, you have either a CUP or a PUD, maybe a variance that's in front of you. You've laid out the criteria for approval in your ordinance. And we have a very specific section on PUDs in our ordinance that lays out a whole bunch of different things that you have to meet in order to be approved as a PUD. Same with the CUP. In your comprehensive plan, that is a much higher level guideline that to kind of cherry pick things. Now I want to be very clear on this. Comprehensive plan is a requirement of LUPA. Every county's got to have one. We have one. And your comprehensive plan should not be ignored when you are considering an application. But you have to keep it into perspective that it's just the guideline. It gives you some very high level goalposts that you're shooting for. The specific criteria that you need to be deliberating and focusing your deliberations on is actually found in the ordinance. And so if you want to resolve an issue with the S Bridge, you really need to be looking at what the criteria is within the ordinance to determine whether or not you're meeting those requirements. I can't tell you from memory what your ordinance says for a CUP or a PUD as it relates to the S Bridge.
But if you had a standard on that S Bridge, it could only handle 2,000 cars an hour.
Yeah.
It's very
Which-
realistic in most of the rest of the world. And you're gonna add another 300 homes, that's not gonna pump it up to 2,000 an hour.
Well-
Really no issue.
Well, I'll tell you this, I know we don't have that in the ordinance. I can tell you there is no quantifiable criteria for any road, but what is in your ordinance is your police powers to ensure that you have health and safety of the surrounding neighborhood and the citizens of the county are protected.
So it would
Ryan,
be
can I ask a
level of
question?
Service measurement based upon AASHTO standards, and that's where your traffic impact studies come in.
Yeah.
And your levels of service.
Okay, question from,
And just on the S Bridge, and that kind of went to that question is, so when we did approve that, I called the sheriff's department to find out how many accidents had happened in the last year. So I knew that the police department had been called 6 times to that bridge. But just because I have that knowledge, that doesn't tell me if that's high, low, or in between.
Right.
So how do we quantify? And I guess the AASHTO standards are where we look to, or, we actually have the sheriff's department respond when those types of things come up with, his information he's not really an expert either on whether that's safety or not.
right. Well, so this ties very closely to the high water table question that we just talked about. Are you going to place the label of is the anecdotal information that, of course, you put that in the record, right? You called the sheriff,
Yes,
you
I
said
did.
there's six accidents, that's in the record. Now, are you going to consider that trustworthy information, or is that an anomaly? That's abnormally high or abnormally low within a certain time span. That's the kind of stuff you got to think about. I think that's an appropriate topic for deliberations when you get to that phase in your public hearings. But you're also talking about a fairly technical topic. And if you go back to the notes that I provided to you, it says you're going to hear really you're going to hear 2 classes of information, 2 classes of evidence. You're going to hear anecdotal information from people who maybe live in the area and say, this is what I've observed on the S Bridge, if that's the topic we're focused on. And 2, if it's, and I've tried to give you some way to delineate when you need to rely more on experts, and that's when it's speculative. What's the future impact of traffic going to be on the S Bridge if this application is approved? It's going to put this much more traffic on there. Do you want some information from a traffic engineer that's trained, that's got professional degree, has some professional experience in making those kinds of prognostications? In a situation like that, it seems logical that you would.
I think the reason I brought up the Eskbridge, and I have no particular application in mind. Since I've been on the commission the last 2 years, we've had half a dozen applications, whether it's a subdivision or an activity center or whatever. And we hear a lot of testimony about Eskbridge, safety issues, capacity issues.
Right.
And so if we're going to use that as a reason to deny or support, I think what I'm hearing you say is there better be some backing up and the reason why that's listed as an issue
Yes.
for approval or denial.
Yep.
And here's the information we
Yep.
got to support that.
When I have to go defend the county in district court, what I'm hoping not to have to grapple with is that we viewed it as, well, I use the term, it's not a popularity contest. Maybe you saw that in the notes. So you might have 300, 400, 500 people all come in and say the exact same thing. But what I'm really hoping to see is that if you had 500 people come in and say the same thing, that there was some part of your deliberations where you as a commission or you as a county commissioners said, there's really something to this. There's a reason why this is believable evidence to me or to us as a commissioner or board. And here's what it is. Here's what it is. You identify whatever it is that you found to be persuasive. And if you do that, the courts are very deferential to that. They say as long as you follow the statute, you make a reasoned statement that supports your decision and it's based on competent evidence that the judge can find in the record, the court's not going to say, I think they just got it wrong. I think they just flat got it wrong and I'm gonna reverse it. That doesn't happen. When it gets kicked back, it's because the judge is scratching his head going, they just made a conclusory statement that the Eskbridge was safe when all the evidence makes it appear like it's not, or vice versa.
Brian, would, using the S-Bridge, would the road superintendent stating it's inferior, dangerous, outdated, that would be supportable evidence for it?
Yeah, I think that you look for people that are credible, who you would find to be an expert that's got experience or and state why.
In our findings, do we need to list those? I mean, that's gonna be a motion to deny, it's gonna be pretty darn long if we start
It can be.
doing all that.
Yeah. I've had multiple conversations with a lot of other county prosecutors that are grappling with this case. This is a big deal for a lot of counties and for a lot of county prosecutors because and this is where the frustration comes from. The court in this particular case doesn't really recognize that you're all not attorneys and that you're not going to view it like an attorney might and be thinking about those kinds of things. And so it's going to be tough. And that's why I wanted to do this training and have this conversation to kind of start the process. But yeah, I think until the court reverses this or the legislature addresses it, and we might see something from the legislature. I've had
Well,
discussions.
Here's where I end up with a dilemma on a lot of these bigger. State Statute 67 and our comprehensive plan, which every time I read, just like in your statement here, standards and criteria which are set forth in the comprehensive plan and other documents.
Right.
To me, that takes priority. And if I can't get around that, I can't go forward with whatever it is. And it's usually, I can pick 2 or 3 out of that list of A through H or I
Yeah.
that don't fit. And I sometimes get the feeling that people are advocating, just look at the ordinances. Oh, the comprehensive plan doesn't matter. But to me, that is the major document. And am I wrong in that assumption? Because that's the will of the people.
Well, kind of, yes, you're wrong in that assumption, and here's why. This Northwest Neighborhood Association made it abundantly clear, if it wasn't before, it is now, that you have to identify the criteria by which you're judging these findings of fact. And according to that court case, that criteria is found in your ordinance. And
There's specifics where this stuff should be in our comprehensive plan and our state statutes. It tells you where to put this stuff, and we're ignoring all that and just
Well-
going to the ordinances. That's what I have a problem with every time.
I understand, and I think I understand your concern. I guess here's my response. The comprehensive plan is a very high level guidance document, and I can show you probably a dozen cases that the court has. It's not uncommon for there to be litigation over the question as to whether or not a certain application met the criteria that's outlined in the comprehensive plan. And every single one of those court cases says, that comprehensive plan requirement is there, and they make it a point always to say that boards should not ignore the comprehensive plan, but they don't reverse it based on a comprehensive plan because it's a guideline. And Gary, for everything you can find that you can justify denying an application, somebody could find the same number of criteria to approve it. And that's because that's what a guidance document is.
And I'll somewhat agree with that, because you read the area of growth and economic development, they want
Right.
growth. There's no question, the comprehensive plan says that. As you read farther, and I've said this many times, it tells you where to put that growth.
Yeah.
And specific areas to put that. I don't know that those two are conflicting statements.
Yeah.
It just goes beyond. The more you read that document, yeah, you can cherry pick out of it, but it is a guideline for what this county wants, people of this county
Yeah.
want it to be.
And that's the part where I'm saying you shouldn't ignore that. You shouldn't just set that aside. There's a lot of conversation in there in the comprehensive plan about protecting the environment and making sure that that you're clustering densities in certain locations that minimize impacts on the environment, minimize impacts on traffic patterns and things like that. But when you compare those general goals and objectives to, let's take one criteria that I know is in the ordinance that's very specific. You're going from a very general based goal or objective down to a very specific criteria. And in our PUD ordinance, I know this because I've been working on the PUD ordinance stuff recently. One of the criteria that has to be met in order for a PUD to be approved is that the compatibility rating has to be a net positive. So you can, am I illustrating the difference between the point that I'm trying to make is you're talking about the overall general objective that the environment is protected to a very specific criteria that your compatibility rating has to be a net positive. And I think what's encompassed in that ordinance requirement is a quantifiable, specific set of a specific criteria that takes into account your comprehensive plan.
See, my problem I have with compatibility rating is we're missing one question right at the top. Does this application meet the goals and objectives of our comprehensive plan? If that's a yes, then we continue on. If that's a no, we're done.
Yeah.
And then you get into the ordinances. Once it meets the general standard, you've got, I mean, you can't be just solid on this.
Right.
But the general standards of the comprehensive plan, then you go to the ordinances. And then you have all this give and take back and forth to make sure that it fits our ordinances. That's how I'm seeing it.
Brian, can I respond to that?
Sure.
So Gary, I understand what you're saying. However, again, that comprehensive plan is looked at differently by different people. So if you're just a flat statement, does this meet the comprehensive plan? Under which objective? And my second point is Valley County is very different than other counties. I'm here and I'm listening to other counties address the issues of environmental standard. And there's some things pushing through the legislature this year that's going to refine this and, maybe help inform us. But where we need to push growth is if you want to be environmentally friendly, it needs to go toward sewer and water, or what is the underlying infrastructure. I know that you guys are talking about, pushing growth toward the impact areas. Our impact areas are very different. McCall's never going to have sewer and water in the impact area. Donley's impact area needs to grow to absorb some of that. So that's a greater conversation about where impact areas should be to help us define where growth goes, in my opinion. And so that's a whole different level of conversation. And I think what is most important in all this statement is that when you guys look at the comp plan, that we're spending time and energy making sure that it is clear of what the community wants to accomplish. Because it's very broad, and comp plans really should be broad. They shouldn't be so narrow that you eliminate things based on just that comp plan, in my opinion.
One of the things I'll bring up is in 67, 65, 12, first paragraph, and this is to Gary's point. It talks about the ability of a political subdivision to meet the needs, the requirements, that's infrastructure, and even calls out schools. And then it says to provide services for the proposed use and when it is not in conflict with the plan. So it loops you right back to the general question of, is the proposed use for a parcel of land following the ordinances? Is it appropriate? Is it compatible with the plan?
Mhm.
And I think that, in a sense, kind of carries the day, because the comp plan, first of all, you have statutes which enable a comp plan. And then from the comp plan, it enables ordinances. And if your ordinances are doing something and allowing something that contradicts our own comp plan, we got a problem.
Right.
That means our ordinances are not supporting our comp plan and not supporting the statute talking about where you build, encouraging development.
Protect the rural character.
Right, so how do you balance all that? And that's, and if you take this clear, narrow read of just the ordinances, the subdivision ordinances in our county, and you ignore the rest of the comp plan, we've made a huge mistake.
There's a lot of the comp plan that can go towards those ordinances too. We all have a tendency to pick and choose of the comp plan how to benefit our argument. It's very broad, and just like Brian said, there's as much in there that can help deny an application as can approve one. And sometimes we decide to not consider that other half of what the comp plan says.
I feel like you have to, when I was on P and Z, it was tough, but once I read all that and I got this in my head, which took forever, I learned to marry the two together. And the problem is that there's 5 of you that have 5 different opinions on how you marry that together to come out with any given application that comes in your plate. And I agree with you about what this court case is saying is we always think we've got to be in a big hurry to prove something. Why? You don't.
The The inter,
Due diligence.
Exactly.
the interplay between the statute, your comprehensive plan, and the ordinances are important. And what, Gary, what you were saying, and Ken, I think what you were saying too, was you got to take into account all three, really, and that's true. And maybe what I'm hearing is that some improvements can be made in the in the way that we promulgate ordinances, and those are always policies that can be reevaluated to improve them and make them better. At the end of the day, though, if we hang our hat only on the comprehensive plan and completely ignore the ordinances without identifying the criteria that's outlined there, we've shot ourselves in the foot, just as if we completely ignored the comprehensive plan. So I'm not saying there's a right or wrong outcome to this discussion. It's just that when we have to produce a written decision from a public hearing, and the outcome, you vote to approve an application or you vote to deny it, what has to come out of that, we know this for sure, you got to have a written decision. It has to be based on a reasoned statement. That reasoned statement has to be what we've just talked about. You've identified the competent and reasonable, believable evidence that's in the record that supported your decision, and you've applied that to the criteria for approval. And you're going to have to go through and identify what that criteria is and state that for the record.
Maybe a statement and a question involved with this. When going through an application and you evaluate, you want to make a decision, you come to a conclusion on your own. Your conclusion can be based on the ordinance, specific sections in the ordinance. It can be based on the comp plan, and it can be based on the statutes.
Yes,
You can't just
yes, but
ignore.
for the most part, I'm struggling to find areas that, for the most part, the statute is just the authorizing document that says counties can promulgate a comprehensive plan and an ordinance specific to their county that takes into account these legal principles. So
And it also gives guidance.
it does.
Because it's still in this rule. It gives us guidance on what's required for us to have in our comprehensive plan and what's allowed for special use permits. Because if you continue down that 67, 60, 12, it tells you the conditions that you can put on there.
I guess the point I'm trying to make is if you look at most of the sections in LUPA, it starts with almost the same sentence, the same phrase almost every time, as part of a zoning ordinance. You flip to the next one, as part of a zoning ordinance, as part of a zoning ordinance. And so basically the legislature is directing the Board of County Commissioners to promulgate an ordinance that says in Valley County, this is how we're going to issue special use permits. In Valley County, this is how we are going to issue conditional use permits. And then you go into the ordinance and you promulgate the specifics that are going to apply to Valley County that might be a little bit different than Idaho County or Gem County.
I think to Sherry's point, Valley County is a very unique county when it comes to land use planning.
Yeah.
Because we have for years, I think the original was in 1975-ish timeframe. When we first started planning and zoning, 72?
The 82 was our first ordinance.
Okay.
72 was the.
Regardless,
70 was the sub.
It's been a few years ago when we started that. And I think there was an overarching philosophy that, yeah, this is required by legislature, but we want to be flexible in how we do things in our own county. And so we ended up with multiple use. And multiple use has allowed certain types of developments wide variety of places, and that's the purpose of it. And it seems that what's going on is there's the multiple use. When you look at the comp plan and our ordinances, you can approve or disapprove virtually any application based on what comes in the door. It's just where you want to land, and I think it's paramount on the 5 P&Z commissioners and the 3 board of county commissioners to interpret that view, because right now that we can do really whatever, and so
You are correct. That is the task that you've been given as commissioners and county commissioners in land use decisions, is interpreting and applying
multi-use
a
ordinance.
multi-use ordinance.
Right.
Yep. And so I'm trying to give you some tools to do that as effectively as you can.
Right.
Reason statement, credible evidence that you can point back to, and the criteria that you've identified. You may have to deliberate. You know, the one thing that was, the one piece of flexibility that we got out of this case was that you didn't have to go through every single set of ordinances and every comprehensive plan. You could identify, look, this particular application is controversial in these areas. And so we're going to have a reasoned statement as to how we're going to resolve the controversy in these areas. If it's, you know, if there's no dispute over certain parts of that criteria, we can, you know, complete that written decision without a whole lot of extra effort on your part. When you are in a public hearing and you're starting to identify where the dispute is, down in Boise, it was over EMS response time. And that's where we need to spend our time and our energy. If it's on the S Bridge, then you're gonna have to dig into the comprehensive plan, the ordinance. Here's the criteria based on whatever it is, a CUP or a variance or whatever, and adopt, make sure that you understand and really articulate during the deliberations, here's the criteria for approving or denying this, and here's the evidence to support our decision.
So if folks down there in Boise, P&Z, or I don't know which one handled it, if they had done their due diligence, had their credible statements put in there, that judge could have looked at it and said, well, they did their homework, and
Absolutely.
this is a done deal.
You'll see repeatedly that the courts say this. They don't want to substitute their judgment for that of the Board of County Commissioners or the Planning and Zoning Commission, depending on what's in front of them. They don't want to be a P&Z commissioner. Their job is to just make sure that due process was followed, the appropriate criteria was identified, and there was a written reason statement that was reviewable in the record. Because they can check all the boxes and say, they don't care what the outcome is, just that the process that was required was followed.
See, and that's where we need, I guarantee we need help knowing this is, we're not lawyers, to make that statement and make that criteria.
Right.
Hold on.
And that's maybe a good point to make, and something to talk about while we're all here is, how can Cinda, how can I best help you with the information that we put in front of you in advance of those hearings, so you can kind of have the I mean, if it's outlining, here's the ordinances, here's the criteria that you need to be considering. I mean, I hate to suggest that, because then it kind of sounds like you're predetermining what the criteria needs to be. But you know, you can narrow it down. If it's a PUD, we say, all right, here's the ordinance that applies to the PUD, and then you have that right in front of you when the public hearing is going.
Well, in the case of the Boise deal with the 4 minutes, could the county commissioners come back and said, as condition of approval, you're gonna have to build your own fire station.
Could have.
That would have handled that.
Potentially, that could have. I think there's a simpler solution, and Boise gets another crack at it, because that's the result of that case, is that it gets remanded back. You need to do more than just make a conclusory statement, and it might be something as simple as Boise City and Eagle City have a written agreement that says Eagle can respond, and then that takes the dispute away. And let's be honest, just like most of the applications you see, they got high centered on EMS response time, but the reality of it is the neighborhood just didn't want the application to be approved. Period. Right.
And Brian, would you reiterate for us too, that each project, especially in Valley County, because we are so different in multiple use zones, every one of our decisions has to be based on that application. So that's one of the conversations that was had back here by one of the other counties I was discussing some things with.
Yeah.
And
Yeah.
you know, I mean, going over that S Bridge, you know, we've approved this subdivision or two subdivisions. So another one comes in. We can use the information that there are additional units coming in, but you still have to look at the facts based on the application in front of you.
So, yeah, and if I understand what you're saying, that's unlike in the other counties where they have multiple zones, where we have a single use zone. You really only narrow the criteria for approval down to, is it a PUD, is it a CUP, or is it a variance? Which doesn't narrow it down like you might in a different county where it's, you know, is this a residential application in a residential zone, and is it compatible with the zoning that's already in place there, or are they asking for, I think what other counties see more often is an application for a rezone, because they're going from ag to rural residential or something like that, so.
Well, and I think too, you guys have probably figured out by now that a lot of the growth and development up here is based around what the infrastructure is available. If you don't have a sewer system in Donley, you're not gonna have the development out there. That's why it's growing. So if you were to come out in the middle of Hasbrook Farms and build a high-density subdivision, there's no infrastructure to support it. Pretty easy to turn that application down. Does that make sense? Donley,
Not if they're 1 acre lots.
well, that's
They
okay.
still have to perk.
You know, if they all perk, you can have individual septics, but if you want to do 8 per lot, there's no infrastructure to support that.
There's going to be a lot of conversation moving forward on water rights. We're going to see a lot of legislation come through Idaho on subdivisions that are not on community wells.
Yeah, I think we're gonna see the day when individual wells are gonna be like water rights. If you're a junior right holder, they're gonna shut your well.
Have the legislation this year.
Right. The other thing that bothered me when I was on P&Z back in the 80s, we took a lot of time with a lot of the applications, because we wanted to have the exact ordinance, whatever code it was. This is why we turned it down. And after 7 years, the commissioners, the county commissioners at that time felt like we were moving too slow. So a lot of us were taken off the board and replaced with people that wanted things to move faster. I think that was personally a mistake. What I'm saying is, don't feel that from me. If you guys need to slow these things down and take more time and make sure you're correct, I'm okay with that.
Because what Brian's advocating, that we have a really good reason for denial. And that's not gonna come at the
Or
end of that
approval.
meeting. We're gonna have to go home and formalize this thing, look at the books, and come back at a later date with an approval or a
Right.
denial.
Potentially, yes. Yep. And,
Some of the larger ones, absolutely.
and
Just a 2-lotter, I don't know.
Brian, have you found that we've been lacking on our official records and our determinations on some of the applications?
so the written decisions, and you guys don't write the decisions, so that's not an issue that you need to worry about. But the source of the information that the written decisions come from, if you put that, if you put that up against the Northwest Neighborhood Association, we'd be getting a kickback. It'd be reversed, because we're making conclusory statements as findings of fact. We're not given good reasoned statements in those written decisions. And so when you, we definitely need to make changes in the way that the written decisions are promulgated going forward. And in order to do that, what we need from the public hearings, all of them in front of both boards, is kind of focusing on those tools that we're talking about here today.
So for example, somebody's using the S-Bridge to turn down applications to PUDC, it doesn't matter. We don't know that the S-Bridge isn't good enough. We don't have any mechanical data that says this bridge is not good enough for all this growth. So, and I personally think the S-Bridge is doing just fine because it slows people down.
Your road superintendent said it was inferior, dangerous, and it shouldn't be any more traffic
Well, it
added to
can't
it.
handle the load, but it is handling the load. Otherwise, we'd have traffic jams every morning at the S-Bridge.
Well, that was the reason I used. Wasn't public opinion. I used his from a road advisory board meeting.
But just so you know, we went out today, authorized to apply for a grant to begin studying to replace the S-Bridge. And as you know, the Bureau of Reclamation has a big say in how much that bridge.
So do your best when you're deliberating, when you have differences of opinion about how you place weight on evidence, what you find credible and what you don't find credible. Deliberate on that and come up with whatever the decision is. It might end up being a 3-2 vote, but once the vote is made, you've made the decision as the commission. Whoever the 3 votes are is the outcome of it, and then depending on what the next step is, it ends up with the county commissioners, and then they take a crack at it. Maybe if it's a PUD, then it's a whole new hearing. They'll take the recommendation from planning and zoning into account, but again, it's a whole new public hearing. The 3 commissioners will then have to say, okay, here's where I find the evidence to support whether or not the S-Bridge is adequate to handle the additional, whether it's a traffic engineer. You think about it, you have a number of sources of information. You got Jeff McFadden with the road department, the applicant's engineer. Maybe you're okay with the applicant's engineer. Maybe you question whether or not the applicant's engineer is biased in the way that they do the evaluation, and you want somebody independent to look at that. And we've had all of those in front of us. Sometimes you want just an independent view, an analysis that they don't have a stake in the outcome. Maybe ITD submits enough information that you say, this is enough for me. I find this to be reasonable. I think that they're, adequate and credible, and I'm making the decision based on this criteria. That's all I'm looking for. I'm not trying to advocate for an outcome on EMS response time. I don't know, 4 minutes is good or bad. That's right. I want my job to be as easy as it possibly can when I'm standing in front of Judge Scott.
But okay, the planning and zoning commission decisions, when they're final, they are appealed to the board if they're going to even go towards court.
Correct.
That's our time to get everything perfect.
And there's gonna be times when it's a 3-2 vote, and you lost that vote. You still gotta support that decision. Same thing happens with this. Sometimes you lose a vote, but you gotta support that decision. Our goal up here is to make sure that you guys have crossed your T's and dotted your I's. These guys are both good with it, and then we're either gonna accept or deny based on that information. The tricky part comes into if there's been ex parte, if there's been people that have gone out and looked at this application before it even came to you. There's all kinds of things that we know is gonna hang us up in court if we end up in court. So those, when you're doing your job, keep yourself unbiased. You can listen to people and you can take that input, which you have to do, but you've gotta stay in that center spot all the time. Otherwise, it gets pretty ugly. You look at what Boise County did and what happened with them. They lost a second one a few years after the first one. And that county has suffered tremendously from that, both those losses. It was almost $10 million total. And that's general fund reserve, general fund dollars. It's not covered by insurance. So all your other programs have got to be shut down while you're paying a yearly payment for that decision. So this is where we're the most liable, I think, as a county government. Is in planning.
Yeah, they learned some hard lessons.
Hard lessons. And those board commissioners have nothing to work with.
First one was 4.8 million.
Then they lost another one, 1.27 or something like that just recently. And it's just like, oh my gosh.
How do we do our jobs if we run scared for fear of lawsuits?
Well, that's how serious your job is. So keep yourself unbiased as much as you can either way. And when you make a decision, base it on the facts. And like Brian's saying, these have got to be solid facts, not some feely, touchy thing that you feel about.
I think if you feel you need a professional opinion from Chris Snyder, whoever.
Yeah.
You get that opinion from Chris, or whoever it is out there,
Yeah.
professional, because I'm no professional on water.
If,
I don't pretend to be.
so I think, let me see if I can kind of summarize some things that I'm hearing today. Number one is document and land on provisions in the ordinances, comp plan, and the statutes, but the ordinance is kind of the nuts and bolts part of it. But they all, in a sense, work together.
Yep.
And because we're multi-use, we can have decisions that would favor an application or reject it because it's a multi-use county. And when we make our deliberations or whatnot, view it as this is prep work for a case that may be taken up.
I,
And one more quick observation. I think I also heard, and I think I just touched on this. Let's say, for instance, somebody lives next door to a proposed development, one of the commissioners, and they drive by it every day because that's how they go to the post office, to the grocery store. And they don't do this because they want to drive safely. And they are aware of something. They can put that input into the record by stating it. And so it's part of the record saying, I've observed this over the last 15 years of my life, and I'd like it recorded in the record.
And I think if it's a water table issue, I think we need to have some test holes and let's see what the water table.
Right.
Geotechnical report. something
Whatever
like
you
that.
call it.
Or
You know,
pictures or whatever.
And we had one here a few months back that it was a storage unit somewhere north of the county. They came in with their test holes, but their data they collected was in June and July. That's not the time of year to test for high water table. So we sent that one back. Asked for somebody else to do that, geotechnical, unbiased. Those are the kind of things that I like to pick up on.
Site visits are,
Not good.
county commissioners and P and Z commissioners like to do site visits.
They
The
do.
attorneys that represent them don't, you
You're
know?
immediately biased when you do it.
Well, they're just so hard to, they're just hard to pull off. So, yeah, don't go out and try to independently be a fact finder. You know, get your information, come back to the make sure the information that you're making your decisions on is in a reviewable record. Like you said, Ken, if you have 15 years of your own experience that you want to discuss and everybody can listen and respond to, and the applicant can respond to it, and the people who are here to testify can hear you talk about that, that's perfectly fine. It's the independent site visits that one individual commissioner does that nobody else was a part of that really becomes problematic.
I think my time of being on the commission, the first time we took, who was on the commission, we took one site visit. And it was not about an application, it was about an ordinance we were considering. Do you remember when we met along Highway 55, somewhere up south of McCall, to talk about the scenic byway?
1,000-foot setback.
Maybe that, I think that was the issue.
Oh, we went to the snowmobile races.
But
Listen
that,
to the noise.
but that was a time when it was a site visit.
And those are totally legit, as long as all 5 of you go.
And they're noticed.
And they're noticed, and it's a public hearing, and anybody can join. That's legit.
That was a while ago, wasn't it?
There's 1,000 ways that plaintiffs love to make them not legit.
Well, the
Don't
worst
do
thing
them.
can happen is,
Yeah.
you know, you
Yeah.
went out, and I'm gonna say, you went out and visited Tamarack, and you saw a map or something on the wall when you were out there for dinner one night. You say that during the hearing, well, your map says you don't have this or that. You just disqualified yourself from that.
There was a big case, this is, I don't know, 10 or 12 years ago, I think, it was up in Kootenai County, and they jumped through all the hoops to do a site visit. They did the notice, the agenda, they had a way to, somehow they figured out a way to record the meeting, which is difficult when you're out kicking dirt clods around. But the group that was opposing this particular application actually attended the site visit, but then filed a lawsuit saying that, well, when the commissioners were out there, they kind of huddled up over here and didn't invite us into their huddle. And so we couldn't hear what they were saying, and therefore, I think they turned it on an open meetings violation or some wonky thing. So you see how those can get really.
Well, Brian, your
difficult.
first letter when I wrote you kind of alluded to the fact, because I questioned, could I go out there?
Yeah.
And I interpreted that letter, yeah, but be careful.
Yeah.
The second letter you sent to all of us, they said no. And I agree, I'll go along with it. But I think it's sometimes unfair to the applicant, because one recently, I wanted to know something about that development, because one landowner said one thing, developer said something else, and I wanted to verify it.
Yeah.
Well, I couldn't, because I didn't see it, we didn't go out, I even suggested we go out. But that makes me almost want to disapprove that application, because I don't have all the facts. And I think it's unfair to the applicant. So what do you do when you have that decision? I went ahead and said yes, because it was 4-1, and I didn't want to be the opposing vote. But in future, if I can't establish those facts, I've got to be a no on the
Yeah.
applicant.
So-
I want to be.
Thank you for bringing that up, because it gives me an opportunity to talk about the second part of the notes that I gave to you. Because I spent the first half of the page talking about what competent evidence is, the second half of the page talking about substantial evidence, and that whole seesaw analogy that I talked about. And that's how you weigh the evidence, and it is a quantifiable measurement. So in the analogy you give, you know, it's like, well, I've got one person that I find credible that says no, X didn't happen. Another person says Y, it did happen. That's part of your job as being the judge of the facts. Do you have enough evidence in the record to tip the seesaw the other direction? And if the answer is no, then the answer is no, and you probably vote no. So that's, I kind of leave that to you to decide how best to do that. When an applicant comes before you, there's a reason they go first. They go first because the burden's on them to prove to you that they have enough competent evidence
to meet all of the criteria in the ordinance. And if the answer in your mind is yes, there's enough evidence that they've presented, they've met all the criteria, their application seems to meet all of the important criteria of the ordinance to approve it, then the burden shifts over to those that don't. And then it's their turn to say, well, did you think about this? Or what about this report that I'm bringing to you that contradicts what they say? And then you have to be the judge and make that judgment call whether or not the seesaw tipped back in the direction of disapproval or not. So you
Brian,
are,
can't we just get more photos though? I mean, and I understand what Gary's saying because I have that frustration sometimes myself. I use Google Earth a lot and I also just look for photos. I mean, so Gary, if you don't have enough information, you know, I think sometimes we rush to judgments, and I think if we table something for a week, let people go out and take pictures and bring back in.
you can,
Let your staff work for you too. I mean,
Yeah.
if you have questions, ask.
yeah, right. So when you're in the fact-finding stage and you need more information, you can ask for more information, obviously. I'm talking about when when public hearing's closed, the information is submitted to the commission or the board, and now you've got to quantify the evidence. Do you have enough? Is it substantial enough to justify approval or disapproval? And if not, why not? And if yes, yes.
And one more, in that related, one more question. When you know in your life experiences that what the applicant is presenting is false, and you know it to be false information, but he's presenting it that way, I have two choices. Either in his back and forth with each of us, I bring that up so that the other four commissioners realize that what he has submitted isn't factual. Do I bring it up then, or do I wait until we close public hearing where he doesn't have a chance to rebuttal that and
Right.
say, hey, that's not factual?
Gotcha. Well, if you wait for deliberations and the public hearing's closed, then there's no opportunity for the applicant to rebut. So logic says you probably need to raise these issues during some phase of the public hearing, so all sides have an opportunity to respond to it.
Because it seems like I'm being controversial with the
Right.
applicant. I'm just questioning as easy as I can the facts that he's given us that I don't accept.
Yeah.
So I'm doing it correctly at that moment to work together.
Yeah, I mean, the way you describe it, it seems to make sense. The only thing that I would caution you in is that early on in the process, everybody should have an open mind, not come in with a preconceived notion that I don't like this or I don't believe that you're actually listening to the evidence that's presented in front of you. Now, if the evidence that's presented causes you question the veracity of what they're saying, there isn't anything in a public hearing that says that when someone's standing at the podium and saying, hey, A, B, C, or D, and you say, that doesn't make sense to me. I need more information, or I need you to explain why you think that, that the water table is not too high to support this, or whatever fact they're presenting. I think there has to be some interaction between the board and the commission and whoever's standing at the podium at that particular time. If you don't, then they're going to go on thinking, well, we got this thing in the bag, and then never get the chance to respond to the concerns that
And that is why I bring it up at that time rather than.
Right, if a P and Z commission is gonna testify as an expert witness, I think that you should do it prior to, public input.
and that
And then the public has a chance to testify.
and there's
The applicant has a
and
chance
there's kind of the whole procedural process of getting through a hearing and following the
the normal flow, you have to take that into consideration, because if you get going down a rabbit hole, then you never get out of it, you know, you never get to the next step,
Would
so.
it be appropriate for a commissioner to, maybe during the applicant's testimony, when they get done, usually the chairman will say, are there any questions for the applicant? To at least put a placeholder and say, applicant said X, Y, Z, I know it is ABC, just want to let you know that I think there's a difference.
Yeah.
Period, let it go.
It seems to be a logical place to do that and get that on the record, so so everybody involved has an opportunity to address the issues, and you're making a good record.
Brian, on that scenario, so say Gary had gotten his packet and there was a question he had. I don't have enough information. I can't, this doesn't make sense to me based on what's in my packet. Can he ask Cinda at that moment to get additional information and inform all of them before the hearing starts?
Yeah.
Or do they need to do it at that point during the hearing?
No, I think so. So one of the really nice things about LUPA is that it's really, really flexible. It does not bind your hands in how you acquire the information, or I mean, even though the Supreme Court doesn't seem to acknowledge that our P&Z commissioners and county commissioners aren't full-time employees and not lawyers, the legislature at least acknowledged that and gave you a lot of flexibility to figure out what works best for our planning and zoning and our board of county commissioners. So there's no hard and fast rules on what you can and can't do, other than the due process things that you need to be aware of. But if you legitimately have questions and you have concerns about what you see in an application, I think it's perfectly acceptable to reach out to Cinda and say, hey, there's a gap here, there's some questions or concerns. Make sure that the applicant comes prepared to address these issues. If you're not satisfied, you can bring it up during, really at any stage in the process to get the question answered.
Well, and I think too that there's gonna be some things that an applicant may give you that's just not true. Whether it's a traffic study or a soil study or a water table study, you know that is not accurate or it's done at the wrong time. You know, I'm not gonna accept the traffic study that was done November, whatever, some evening. And those are the kind of things you gotta be aware of, watch for. That solid evidence they're presenting is true. And if not, then, hey, I want an independent person to come in and do that.
But you request information from an applicant, and he provides that information, and it's sorely inadequate. It's not even what you wanted, yet he checked that box. I can't accept that. I mean, I've got to go back and say, this is unacceptable. I try to give them parameters, or on federal and state laws, if they quote something that's not correct, do I then ask Cinda to look up the discrimination law or whatever the law is and have it for the next meeting?
Absolutely.
Is that how you do it?
Very appropriate.
On the traffic one, I mean, we would consult with our engineer. I mean,
The worst
That's
case
why we have
scenario
an
is if you
engineer.
catch a developer in a big lie. Now he's lost all credibility. That's a really tough one, because now you have to kind of have faith after that.
Well, and you go back to the applicant and just flat say, this is not what I wanted. You know, give me what else I want. Again, I think sometimes we jump too fast to make decisions. And if you're, just hold them accountable to the knowledge you need to make a good, decision based on the facts in front of you. If they don't want to do that, then you make the decision on what you have. But if not, send it back to them. I'm sorry, this isn't adequate.
I agree 100%.
so this is a good session, but we have scheduled Payette Land Trust and North Lake Sewer to come in and talk to the Planning and Zoning Commission.
We passed.
Before we get
passed
to that,
Yeah, well, the training was scheduled from 3 to 4.
I have a few more questions and then we can be done, and we can be out of here, but I think you guys understand or realize that, this is a pretty heavy job. And I know you guys take it seriously. My concern is that I think we're gonna get a lot more applications coming. The workload's gonna start moving. Excuse me. We may have to look at 2 days or 3 days a month. Is that okay with you guys?
Are you gonna start paying the planning and zoning committee?
It's a possibility.
No, it isn't about the pay, but it is getting, I mean, we're already at 2 hours. We probably average about 8 hours of meeting time, and that doesn't include
And I think,
our reading time and our free time.
I think you're gonna get busier, and I guess what I'm saying is, if you get to that point where, hey, this is more than what I signed up for, you gotta let us know.
I think our biggest concern, maybe I'm speaking out of turn for the board, is not so much for us, but it is for staff.
Well, we've got Cindy pretty well staffed, but if she needs more staff, she's gonna tell us. Everything up here is exploding from what we're used to. So it's gonna be coming a little harder, a little faster. What I'm saying is take your time, don't feel rushed. That was really an interesting time back then. It destroyed a lot of the relationship between the county commissioners and P&Z, and then let a lot of people go because we weren't moving stuff fast enough. We're just trying to do a good job.
I think everyone on this board knows the time commitments. We've looked over the calendars. We know right now that we expect 2 meetings per week, or per month, pardon me.
It's 2 per week.
2 per week, Scott, from now on.
Now he wants to be paid.
And now, you know, it's not unusual for the meetings to go to 10 or 11 at night. But I remember in 2006, it was the same way. There's always an ebb and flow.
Right. But just know that we've talked about it on the commissioner level, that we get to that point, we're gonna probably looking at salaries.
You can't pay P&Z.
No.
But then you have to run elections, don't you?
That
Being's
was,
elected.
that was a complete joke. I think we all know this is our civic duty and we're happy to be
And
volunteers.
it's a really cool job, you're gonna learn a ton.
You know, Eld, if we start doing what the comp plan says and putting these developments where they should be in the county, we won't have a heavy workload. We start approving these over on then, yeah, it's gonna fill up. I think, I don't have an agenda, I really don't coming in. But as I read the comp plan, we can isolate these. And the developer will know not to go out in the middle of nowhere and try to do a 400 thing
It's gonna
subdivision.
be too expensive to build the infrastructure.
Irregardless, you know, what,
We
but
also have a lot of history that has placed some prior history that we can go develop background. And so we have to, I mean, sure, we can,
There's our dilemma. You've just heard our dilemma.
or
Oh, yeah.
even non-productive background. I'm just
Love
saying, I think we can't just be,
I-
yeah,
I-
black
I'm
and white.
I know we need to go, but I think Gary and Callan have just very adequately vocalized the dilemma that we're facing about where development should happen. And I think we need to have another work session of what we, and have that as separate topic.
Well, I know we've talked about overlay districts for some areas, like our rock quarries, where we need to make sure we can develop those rock quarries. Maybe that's an overlay district that we can start thinking about. People won't go up there and buy a lot and build a house on our rock. It's in short supply in Valley County. Travel sources.
We've talked
We
about
know that 40% of the county is underwater certain times of the year. We know that floodplains, all that stuff, so there's a lot of overlay already happening, just not on a map anywhere yet.
Right.
Those are some ideas to look at.
One last closing thought from me, if you don't mind. Remember you wear 2 hats. And when you're making a quasi judicial decision, that is, you have a specific application in front of you, you have a certain procedure and a set of criteria that you have to follow. And that's what we spent today talking about. When the next discussion comes up about where and when development should happen, that is your policy-making hat, and that's a different hat.
and a different set of criteria, and try your best to distinguish between those two and not overlap them, that you start blending your policymaking mindset into your quasi judicial decision-making and vice versa. I would definitely encourage another discussion about the policy and what changes you all want to see made and how we can get those done. But those are definitely two different hats, so. Okay, I've, as usual, 30 minutes too long.
He's a lawyer.
Thanks, Brian. We do appreciate
Yeah.
all of that you do and all of your help.
You're welcome.
Thanks, Brian.
It's nice to be back in business with you.
See you all later.
Okay, with the work session over, this meeting is adjourned.